Welcome. Today we've got something a little bit different. I've asked Melanie, Conn and Jess McColl from Family Court Solutions to speak with us about the way that they're working in providing legal support for people in, I guess, an unbundled fixed fee sort of way. One of the challenges that we're working really hard to overcome is that there's sometimes a bit of a barrier between mediators and lawyers. And that's really to the detriment of clients being able to make good informed decisions. Hopefully hearing from Melanie and Jess will be helpful. So thank you very much.
Thanks, Joanne. Well, thank you for coming in your lunch hour. I'm obviously Melanie, you can see on the bottom of my screen. I'm a principal at Family Court Solutions. And here today we also have Jessie.
Hi.
Who is the other principal of Family Court Solutions. We're going to talk to you today about how lawyers can help your clients. Jessie and I started Family Court Solutions just last year, and we were both working at Legal Aid, and we were working at the family court and the local court. And our job was to be available for anyone basically who came in and needed family law help. And what we found was that there was a lot of people coming through who didn't qualify for legal aid, but also couldn't afford a lawyer. And they were just getting smashed in the court and privately. We saw that they were getting into situations that were not in the best interests of their children and were not fair and equitable in terms of their property. So we started Family Court Solutions so that those people would have somewhere where they could get the really essential parts of legal help at an affordable price. So I'm going to share my screen now.
Oh, good.
Good? Great. So I've made us a little picture here. This is you at the top. You're the friendly mediator with your sunglasses. And this is how I think roughly the process goes. You have your intake, you work out if the parties are suitable or not suitable for mediation. They come to the mediation, they might form an agreement, hopefully, or they might have no agreement. So the orange is where lawyers can be of assistance towards you. So in your mediation, in your intake interview, you might be talking to someone about their parenting matter, and you're obviously trying to assess if it's appropriate to do mediation, and you're trying to build rapport, but you have some red flags that are going off in the back of your mind. They might be saying things like, well, he ended the marriage, he left us, so he can't see the kids. Or they might be saying things like, well, I'm the father, so I get to have 50-50 care of our baby. Lawyers can help at this point. Lawyers can be the bad cop to your good cop and solve your pain points really by giving your client the legal context. So making sure that they know what a relevant legal issue is, and making sure that they know what the options are within sort of the legal information. The biggest thing that we do when we give people advice is we manage the client's expectations. So we can really reality test their options. We can also help them gather important information, particularly in relation to property, so that they're not using up their sort of valuable mediation time if they don't know yet, for instance, whether or not they can actually afford to take on a loan to repay the mortgage of the house. So definitely at the start, if you have clients and you're trying to sort of nudge them into the direction of coming to an agreement, lawyers can help you in these ways. As well as managing their expectations and reality testing their options, there's another thing that you should be aware of, in that we can tell them what happens if mediation doesn't work. And we can make it very clear exactly what it means to go to court and how much it's going to cost. So some examples. I spoke to a lady recently, and she was preparing for a property settlement, and she had the idea in her mind that she must keep the house. She really wanted to keep the house. And she'd done her intake interview. The mediator had said, maybe you should get some legal advice about that. And she came to us and I spoke to her. I was able to help her make a full balance sheet. And when we went through that process, we discovered that when she was saying I must keep the house, she wasn't taking into account all of the other assets that they had. So I could give her advice about what the Family Law Act said and make sure that she knew what was an appropriate range, taking into account all of the relevant legal information. I also made sure that she gathered all of the information that she would need so that when they got to mediation, she was actually prepared to put forward a proposal. There was another fellow that we spoke to recently, and his name was Michael, and he had a parenting matter, and he had the idea, which he discussed with his mediator in the intake, that he should be seeing their 5-year-old every third weekend, because that was the arrangement that they had had before mum and the daughter had actually moved. But they had moved 4 hours away, which he had agreed to. So we were able to give him advice about what the law says and what the law was going to take into account, and obviously help him to see what was in the best interest of his child. So if you're sending people to get legal advice, what should they do to get the most out of their session with a lawyer? They should totally put some time and some thought into considering what they would like to know. So they need to think about the purpose of their session, and it'd be even better if they had a list of questions that they wanted to discuss and if they had some information with them. The last point there, I've got they should consider where they're going to conduct that advice session. So we're an online business. We talk to people over Teams and over the phone, and we have had some crackers. I had a fellow who was a couple of months ago now, and I rang him for his advice session, and he was actually in the middle of getting a haircut. So I'm not sure how much he took in while he was getting his buzz cut, but generally, if clients are going to spend their money on coming and seeing a lawyer, they should make sure, obviously, that they're prepared, that they know the questions they want answered, they've got the information they needed, and they're ready to listen and be present for that conversation. So we're back in our mediation system happening here. We've had our legal advice at intake. The next way, I guess, that lawyers are often involved is when someone is unsuitable for mediation. When someone becomes unsuitable for mediation and they have to sort of continue with the pre-action procedures before they come to court, what that means for them as a next step is that they have to negotiate with the other person in letters. They have to send a letter called a notice of intention. So it's written down, it sets out the issues that are in dispute, it makes a proposal, it lets the other person know that they're going to go to court. So people can write this notice of intention for themselves. We actually have a guide that people can purchase that tells them how to write it, because even though it might sound easy to send someone a letter to let them know that you're going to be going to court, it's quite difficult to make sure that you have actually identified what the legal issues are. So in this next slide, I've put a little picture here of some money and a watch, because this takes both of those things, time and money. To actually start the court process, a client needs to submit documents. There are 6 different documents that they have to do. They have to do an application where they tell the court what they want. They have to do an affidavit where they tell the court the story of what has happened. They have to have their certificate from you saying that they looked into mediation, but they were not suitable. They have to do a notice about family violence and child abuse. There's a couple more there that are more procedural about making sure that they have really tried to resolve this before they come to court. So if someone is unsuitable for mediation, they're faced with negotiations through letters, which is the notice of intention. Then to actually start the court proceedings, they need to complete these documents. If they were to go to a traditional law firm, they charge in stages. So they would normally say, you need to put an upfront amount in our trust account, and we estimate that that will get you perhaps your court documents drafted, or perhaps up to the end of the first court event. Realistically, those fees for those stages are expensive. They can, if someone goes all the way through the court process, and if you're not sure what happens at court, this is a sort of timeline that the court puts out. Obviously, court is not really as linear as this might suggest, but it gives you a good overview. So if someone comes to a lawyer and they're here before their first court event, they've got their Section 60I certificate, they're not suitable for mediation, it's likely that that lawyer is going to tell them to go from here to the end of the final hearing is going to cost them $100,000 or possibly more as an estimate. So lawyers charge per hour, and usually they provide an estimate in stages. So how much they think it will cost to get to the first court event, how much they will think it will cost to get to the interim hearing, and so on. So the reality for a lot of people, if they're not suitable for mediation, is they simply stop. They get overwhelmed. They do nothing. They're not sure where to go next. They might talk to a few lawyers. They can't afford those lawyers. And they often just sit there stuck for a while. This means that they mightn't be seeing their children, or conversely, they might become criticised by the court later for not letting the other person see the children. They might be experiencing impacts on their credit rating, which will affect, their ability to get another loan later on, or they might simply remain in the same house as the other person, still just separated under the one roof because they haven't been able to work out how they're going to move forward. So we've looked at legal advice in the beginning and how lawyers can help your clients and help you move mediation forward. And we've seen what happens if someone is unsuitable for mediation and they have to go to court. Hopefully the next thing that happens is that you do get people who have agreements. And I'm sure you probably already know this. There's lots of options for recording agreements. People can just decide, right, we're going to do this, and that's what they do. They can have parenting plans, which probably you're pretty familiar with. They can go to a lawyer and have a binding financial agreement written up, or they can get consent orders. So orders where the two of them have agreed and they're asking the court to turn that agreement into a court order. So we would, in a sort of general sense, usually recommend that consent orders are appropriate over binding financial agreements because they're an order of the court, so they are enforceable. Some of the advantages or disadvantages, depending on your position, is that the court doesn't just automatically make the agreement into court orders. The court thinks about whether it's actually in the best interests of the children or whether the property division is fair and equitable. And consent orders are usually more affordable than a binding financial agreement. So I guess if you've got clients, they've come to the mediation and it looks like they're going to have an agreement, when should they be thinking about and you be thinking about getting ready for consent orders for property? Well, if what we're talking about at mediation is their household possessions and their furniture, probably it's just fine to write it down and, everybody goes on their way. They should definitely get a legally binding agreement if they're going to transfer the ownership of the home or if they want to split their superannuation. I guess that can be quite clear-cut. It can be less clear-cut when it might be appropriate to have consent orders for children instead of having a parenting plan. Some things to think about is that a parenting plan is obviously very flexible. It can be easily updated and changed. If you have a court order, that court order is meant to last until those children are 18. So you really have to be certain as to what arrangements are going to be best for them until that time. And that generally means that while children are young and their needs are changing all of the time, it's better to have the flexibility of a parenting plan. Sometimes, or another thing to think about, is the level of conflict and animosity. Sometimes having court orders can calm a situation because everybody knows where they stand and someone who mightn't have been seeing a child has certainty. Other times, the parties are already working well and it's simply not necessary. They don't need it. So how do people actually get consent orders? Well, again, there's an application form. They have to lodge it with the court and the court considers it. And hopefully, if it has been documented in the right way and the court has all the information, it does seem to be in the best interest of the children. It does appear to be fair and reasonable. You send your documents in and you get your consent orders back. So consent orders is a much shorter and faster process than going to court and having a judge make a decision about something. So what does a client need to leave mediation with if they want to get consent orders? Definitely their agreement needs to have covered all of the issues. They definitely need to understand what their agreement actually is. And it would be helpful if there was a heads of agreement document that had it all written down, and in property matters, a balance sheet. So we'll talk about those a bit more. One of the, problems that we see when people have been to mediation and they come and they want to get their consent orders is that we type everything up, and after we've typed it up, we go, oh, hang on, what about this? What about that? So if they haven't quite worked through all of the issues, it can definitely become a problem if they go to use a lawyer and the lawyer suddenly says, you need to think about this, you need to think about that. Their agreement doesn't always hold up. So some of the, most common issues that people sometimes leave off, particularly if they haven't actually been to mediation, where you're used to dealing with all of the issues all of the time, but if they're writing it themselves, the start of the year is a classic one. Often they have an agreement for the Christmas holidays that ends on the last Friday before school goes back. But then school mightn't go back until Tuesday or Wednesday. And people often end up arguing about those 4 days at the start of the year and who's going to get those, particularly if the kids have been with the person who is not the primary carer and the primary carer says, no, I want them back. I want to be able to do haircuts and school shoes and books and pencils and all those things. So that's a common issue that we see. The other thing that often comes up is people have agreements for week about, and they want to keep week about in the holidays as well for, say, the end of term 1, term 2, and term 3. But then they can get into a muddle with the start of the next term. So, and then they can argue about whether it flows on from the holidays or whether, say, the first week of term is always dad's weekend or mum's weekend. So these are some of the issues that should be covered in your mediation if you're going to get consent orders about children, because these are the issues that the lawyer or the lawyer will bring up basically when they're writing the court application. If anybody thinks that a copy of the slide would be helpful to them, just put your email in the chat and Jessie will write it down and we'll send you a copy afterwards. So most of these concepts I'm sure that you will be familiar with. In terms of property, some common pitfalls that we see in people not covering off all the issues is what happens if someone doesn't comply. So they get to mediation and it's great because they're on the same page and they've decided someone's going to pay a sum of money. The problem arises when it turns out that they can't actually pay that money. Maybe they were going to get a loan and the loan fell through, or maybe they're going to sell something and they thought it would sell for more. So because of those issues, if they come to a lawyer and they say, please write my consent orders, the lawyer will always say, well, what if? What if actually you can't comply with that section? What's going to happen? Or what if the other person doesn't comply with that? What's going to happen? And the last two there are, again, common pitfalls that people call us back about. They say, well, we're meant to get the property ready for sale, and I want the other person to clear out the spare room, paint it, and fix the veranda. And it causes problems if people haven't already thought about that before they go to get their orders, because it's obviously too late to add in afterwards. And the last issue there that comes up that sometimes gets left off with property consent orders is if you have to sell something, who's going to pay for the expense of that? And we might be good at thinking about that in terms of a house, but sometimes we leave off the expenses in selling a car, for instance, or selling a caravan or a boat. And these are the common things that you would want your property orders to consider and to have been worked out in mediation. I guess the biggest thing that you need to think about in terms of property compared to parenting is probably those last four, the how and the when and the who and the what happens if they don't. Because in the property matters, you really need to spell out how things are going to happen. So as well as coming to their lawyer with an agreement that might leave off some issues and that causing problems, the next biggest thing that we find is that the agreement falls over, because even though someone might have agreed in a general sense, they haven't really understood the reasoning behind that, and they haven't understood the questions that are going to be asked in the consent orders application. So this is actually what part of an application for consent orders looks like. And you can see, as well as having the percentages, which we usually get worked out during your mediation, the parties have to answer these questions. So even if up here, someone might be happy to say, yes, the applicant should have 60%, sometimes answering these questions causes agreements to fall apart, because they're asked directly, were the financial contributions the same? Were the non-financial contributions the same? Were the contributions as the homemaker and the parent the same? So sometimes we find that people might have been to mediation and they've come up with an overall agreement as to who's going to get what, but then it gets down to actually ticking the boxes, and it puts people's back up to tick that the contributions were not the same. So I guess it's important, if they're going to go through this process, that they understand that these are the underlying issues. That's why they've come to this agreement up here. And that will have to be acknowledged openly. In parenting matters, we have the same problem. So you might have an agreement that one parent is to have sole parental responsibility, and the other parent has agreed to that in mediation. But when it comes time to fill out the consent orders, they're asked why. And when it comes time, they're also asked, is the child at risk of family violence? Has there been family violence previously? So I guess if some of these bigger underlying issues aren't tackled really openly, when it does come time to get the consent orders, people end up disagreeing because they don't want to tick the box which says, yes, there was family violence in the past. So I can't believe I'm at the end already. I must have talked very quickly. I think it's because I can't see many little faces out there. Most people have their camera off. So Family Court Solutions is obviously the service that Jessie and I have created because we felt that there was a real need for ordinary people who were employed and working and didn't qualify for legal aid, but couldn't stump up for these large amounts of money at such a difficult time, to have access to justice and to be getting the same results as everybody else. So our business is just for people who intend to manage their separation, and if they get to court, to manage their court process themselves. So we don't take ongoing clients. We don't come to mediation with people. We don't write letters for people, and we don't go to court for them. Our fees are fixed, so they're upfront. They're generally more affordable than the option of having a lawyer represent you all the way through. And the next screen shows exactly what they are. Obviously, we are qualified and experienced. It's never a great idea for your clients to get legal advice from Facebook. If in doubt, totally refer them to a lawyer, a qualified lawyer. We have a fast turnaround for appointments. I think the biggest difference between Family Court Solutions and a traditional law firm is not just the fact that we have fixed fees and that is upfront and people know where they stand, but it's that our mentality is that if people come to us for an advice session, we will help them solve their problem in that session. So we are not trying to build a long relationship in which the client will have to continually pay. We're trying to get people in and to set them up on the right path so that they can continue to represent themselves at mediation, or if they need court orders, in the court afterwards. So there are fees there. If you're thinking about where your client should go, we charge $350 for a 1-hour advice session, $2,000 for consent orders, or if they're not suitable for mediation and they really need to go to court, it's $3,000 for an initiating application. So does anyone have any questions? I feel like we've just churtled through a lot of information. What are your thoughts? Does anybody regularly refer to a lawyer now? Put your little hand up and we won't even make you put your camera on.
Thank you. That was beautifully structured and really, really clear. So I'm thinking what I might do is turn the video off, and
Okay.
then people will probably feel like popping their little faces up, and we can have a bit more of a conversation.
Well, that would be great.
Just put record back on so that
If
the end of
people want to refer to us, they can just telephone us 1300 525 673 or send us an email, or you can book free consults through our website.
Yeah.
And
of
reach
course,
out on LinkedIn and social media as well. We're all over that.
Excellent. And of course, when we're referring clients for legal advice, they've got to go to 2 different firms anyway. Conflict of interest. We need to have a selection of firms that people can choose from, because you can't advise both of the parties, even if it's consent orders.
Yes. Yeah.